Thank you so much for joining us today. As I mentioned before, today we'll be talking about the DEI Backlash that many of you have probably heard about. This is the diversity, equity, and inclusion programs that were initiated and the current landscape for them. Today we'll be talking about the nature of the backlash and what the temperature is about this topic, as well as what employers and companies can do to stay on the right side of it, and well as for employees to know a little bit more about what's going on. As always, and I say this every time, just as a disclaimer, this webinar is for informational purposes only. We're going to be talking broadly about this, just to give you guys a lay of the land and get your finger to the pulse on what's going on in the environment. However, if certain issues arise, as every lawyer will tell you, it will depend on the fact specifics of your case in terms of what is the best course of action. If anything we talk about today raises some concerns for you about your own workplace or your own company, please do reach out to us. We'll be able to give you more bespoke advice on those topics. Today's webinar series is going to be hosted by yours truly. My name is Charles Miller. I'm a partner here at the firm. I'm also joined by my good friend Clifford Singh, who's also a partner here at the firm, heading our corporate commercial litigation division. Really happy to tap into his expertise today. And we are here with Achkar Law. Achkar Law is a specific specialist in all sorts of litigation disputes within your workplace, within your company, corporate commercial. We work across Ontario and all across Canada. We are here to assist, especially when things get dirty. We know exactly what to do and to keep you out of the muddy as well. So without further ado, let's step into today's topic, which is the current DEI or diversity, equity, and inclusive landscape. As many of you have probably heard or seen across the news, there has been a big call for the rollback or dialing back of DEI programs. And that's because these programs have faced a lot of increasing scrutiny, both externally and internally, with people having different views about the program's effectiveness, its necessity, as well as the impact it's had on the business, both being good and bad. As a result, some organizations are scaling back and altogether eliminating DEI programs due to public and political pressures. But here's the question. As a company, you are caught in the middle of it. You see, in order to understand the DEI landscape right now, what it means for your business, we need to have a little bit of an understanding of where this all came from. Around April of 2020, the government of Canada initiated a directive for including DEI programs within the workplace. The directive was a little sparse on details, but the idea being that they were directing companies to put into place policies and procedures for promoting a diverse and equitable workplace. And the objective was to remove barriers so that workplaces were inclusive, so that economy would flourish as a result. And all together, a wonderful idea. And companies, wanting to be on the right side of history, made the correct decision and made the right decision to get on board with this, jump on the bandwagon. What a great bandwagon it is. Diversity, equity, inclusive, everyone can get on board with that. A lot of companies initiated DEI programs at the government's direction. The problem is that, several years later, we're seeing a bit of a backlash in terms of how these programs panned out. Were they effective? Were they necessary? And did they actually cause more harm than good? And now we've got companies stuck in the middle. As a company, you were told to put these programs in place. Great, you did. And now you're being told that these programs don't work, scale back. So what do? Because in order to achieve virtue of diversity, equity, inclusion, especially be on the right side of history and the right side of legislation and the law, companies are left holding the bag. They're the ones who will face political pressure. They're the ones who will face legal liability if they do this wrong. Good news is we're here today to talk a little bit about how you can stay on the right side of legislation while also doing your best to stay on the right side of diversity and inclusivity. A lot of what we're talking about today with understanding how the DEI landscape got here, we could also touch base a little bit about Aristotelian ethics. Aristotle, the old philosopher, talked about virtue being basically the swing of the pendulum, with virtue being in the center and people trying to hit that center point, but swinging back and forth, not always getting it, but doing their best to circle around. For example, he talked about the virtue of bravery being in the center, and at one end you've got cowardice, and the other end you've got brashness. And in order to hit on the virtue of bravery, some people swung into brashness, some people swung into cowardice. We're seeing the same swing today with DEI landscapes. We wanted to land on the virtue of a diverse and equitable workplace. We include these programs, and now people are saying we went too far with it. And now we want to dial back, and as companies, you're like, well, I don't want to go too far away from the virtue. If I dial it back, will I be on the wrong side again? How do I do this properly? Well, let's talk about that today. Now, I mentioned that a lot of the DEI backlash is coming from pressures, both external and internal. By external pressures, we're talking about clients, investors, and political advocates all saying these DEI programs didn't work. They went too far. They caused more problems. It was a big problem. Get rid of them. A big issue being that it made people uncomfortable or it impacted the economic value of the product the companies were bringing forward, with too much focus being on these programs, not enough being on talent, being on product, and being on just making a good environment. However, although companies are being called and asked from external sources to pull back the programs, I said before, companies are left holding the bag. What are the legal considerations about pulling these policies back? Will the Ontario law even allow me to pull back these programs? We're going to talk more about that. And then there's also the internal pressures we can't forget about. Companies implementing these programs, many of you can talk about it and have heard some of your employees pushed back. They didn't like these programs. They were too onerous. They created a weird tension within the company. They made hiring practices slow down. They made bringing out products slowing down. And then you have employees who you were meant to assist. Again, the purpose of the DEI programs were to remove barriers. Well, some of the people that you were meant to remove barriers for actually spoke up and said, this actually didn't remove a barrier, or it missed the mark, or the biggest complaint is it was completely tone deaf. It didn't actually hit the target that they wanted to hit. Now, mind you, I'm speaking very generally. There were some DEI programs and initiatives that were implemented that worked wonderfully, but we are hearing the chorus, which is many of these programs didn't work out, and they're being told to claw back, and they're being told that the employer has to claw them back. Meanwhile, the employer has all the liability. In case of internal pressures, if you pull back these programs, are you now going to be left with employees saying that now that you've removed the program, you've caused discrimination in the workplace? I used to have that support. I used to have that policy that was great for me. And now it's gone because the employer dialed it back. So the employer trying to do what's best has all the liability. As I mentioned before, with these external and internal pressures, companies here bearing all the about implementing the programs that the government asked for, and now possibly pulling back the program when clients and employees and customers and everybody's asking you to dial it back. The problem is that if you dial back these programs incorrectly, if you do it in a way that's not smart or processed, there is a risk of liability and claims being brought against you, such as constructive dismissal claims, saying that implementing the programs changed their employment conditions so much that they had to go, and that you've changed the employment condition that they can't work there. And then an alternative, pulling back the DEI initiative, made it so that they've lost the support they had, and you've changed the term. You might also even have human rights complaints of people saying, hey, you include this DEI initiative, but it didn't help my employers might include these programs hoping that everyone who's marginalized is assisted. But if it wasn't implemented correctly, then those who weren't supporting the program will cry out that they've experienced discrimination because everyone got helped except them. Same thing, if you dial it back, you're now removing supports that you promised. And then the last one being, we've heard a lot about employers saying that many of their employees have come forward to say that the DEI initiatives actually created an imbalance of unfair treatment. It offered too much support for other employees above what was needed to remove a barrier. Remember, the goal was to remove a barrier, to make everyone equitable. But some people and some employers have come forward to say that many employees complained that these initiatives went too far. They not only removed the barrier, but they promoted one group above another, causing marginalization in the workplace. Again, very unfair to the company who's trying to do its best, be on the right side of the law. But again, employers are left holding the bag. So the question employers have is, what do I do? How do I stay on the right side of history? How do I stay on the right side of the law? If I'm going to dial back these programs because everyone says I need to dial them back, A, should I? B, if I should, what protections do I have in place? And probably the overwhelming question that might be on everyone's mind is, why did we bring these programs in the first place? They were there to remove a barrier, but didn't we already have something in place to help with that? It's true that in order to stay on the right side of legal liability, we always direct our clients to focus on the legislation that's in place. You got the Ontario Human Rights Code and the Employment Standards Act. Before the 2020 directive was brought in place about DEI programs being brought into the workplace, with the objective being to remove barriers, there was already legislation decades prior that gave companies directions on how to ensure that they had a barrier-free workplace, one that was inclusive and equitable. The Ontario Human Rights Code dictated that employers had to make sure they accommodated everybody, that they made sure that no one experienced discrimination in the workplace based on a protected ground, such as race, religion, or place of origin. Then you also had the Employment Standards Act ensuring that you couldn't have a harassment in the workplace. You had to make sure that you actively investigated harassment and ensured no one experienced discrimination in the workplace. So as an employer, I'm going to let Clifford talk more about this in a second. As an employer, when we're talking about that shifting pendulum, trying to land on the virtue of a diverse and equitable workplace, place. One way to guide us to make sure the pendulum doesn't swing too far away from it is to think about the legislation that's already in place that was there to ensure we had a barrier-free, workplace barrier-free from all sorts of discriminations. Ways to ensure that if there's a legal claim, this guides how to ensure that you are not liable. These are policies that were already in place, policies that can guide you. And to talk more about what your company can do to stay on the right side of the swing of the pendulum, dealing with the DEI backlash, guiding with the code and the law, I'm going to bring in my good friend Clifford Singh, who's got almost a decade's worth of experience dealing with litigation at the corporate commercial level, knowing how to keep everybody out of trouble and what to do if you do get in trouble. Clifford, if you wouldn't mind taking it away, tell us exactly what companies can do to stay on the right side of virtue.
Thank you very much, Charles. And just dovetailing on what Charlie was mentioning, I would really like to emphasize that this is an issue that isn't a one-size-fits-all issue. It's really going to be contextual as you move from case to case, employer to employer, employee to employee. We have to keep in mind that context in this particular analysis is really everything. Now, with that being said, we do think that there are practical, pragmatic steps that an employer can put into place to get out in front of some of these issues. Starting with just dealing with the external backlash Charles had mentioned earlier. This comes from your clients. This comes from your shareholders. This comes from people who have some kind of involvement in your business. The most important thing, and Charles did mention, is ensuring that any of these initiatives align with the Ontario Human Rights Code, the Employment Standards Act, and I also direct clients to look at the Occupational Health and Safety Act, because there are occasions where issues of DE may touch on pieces of that legislation as well. What's principal in this analysis is, are you in compliance with the law? Because if you're not, you're opening up your doors to a potential liability. And as a corporate commercial lawyer, as well as an employee, I am always trying to ensure I'm keeping my clients out of situations where there may be a potential liability lurking below the surface. One of the things I really enjoy doing when I explain these kinds of issues to my clients is framing diversity, equity, inclusion as a business asset or a business proposition, opposed to seeing it as something that's pushing down certain employees in the corporation or the company. I like to frame it that this is actually an opportunity to grow the business, as opposed to having knee-jerk reactions to DEI directives that may come from the government or that is popular in culture at the moment. We can frame and reframe these kinds of obligations through the lens of business goals and legal requirements. And in my experience, that's far more palatable. That's far more appealing to stakeholders, to clients, to shareholders. The other part I like to emphasize is you want to avoid, as an employer, dealing with potential legal and quasi-legal claims. You don't want to have to deal with a constructive dismissal claim or a human rights claim. And those occur either opposite spectrums of the DEI debate. So it's needless to say that this issue is fraught with potential liabilities. And if you are able to get on in front of it with a policy and a corporate protocol that aligns with the law, you're going to reduce potential red tape for legal expenses and liabilities down the road. Now, at the more micro level, you're going to have to start equipping your managers and executives with the right messaging that's able to handle the outside scrutiny, but also be in compliance with the law and have your employees satisfied that there is a balance. And that's the other really critical element I wanted to raise, is this is a balancing act. This is not a mathematical formula. As I mentioned earlier, every workplace is going to be a little bit different in that respect. But the goal of the employer, through its management and executives, is to balance both being equitable, being diverse, and including as many people as you can and as is reasonable, but also not compromising the efforts or the contributions of other employees. I've found this crops up oftentimes very frequently with long-standing or long-term employees. They feel that when there's been a change kind of in the corporate cultural policy, that they're somehow being targeted or their contributions are being diminished. And it's really up to the managers and the executives to explain, no, we're not pushing you down. We're in fact raising others up. And as the old saying goes, a rising tide lifts all boats. So I think that's something that's really important in terms of the corporate level, getting it down through the chain of command to the managers and the people actually in the trenches and in the field, so everyone's aligned in that. The one thing I do like to point out to my corporate clients is that the public sentiment may shift. And Charles mentioned this in terms of the pendulum. There may be a world in 5 years in which DEI is all the rage again, as it was several years ago. We simply don't know how social sentiment is going to change. But the fact of the matter is, regardless of social sentiment, a company can't put satisfying popular opinion over their legal responsibilities to their employees, to their stakeholders, as well as their ethical responsibilities to their employees and their stakeholders. Again, companies are often going to find themselves, and executives and managers are going to find themselves in situations where they're having to not only satisfy the complaints or address the complaints of the public, they're also fighting with their own internal issues with regards to managers, executives, employees, staffing, where everyone's kind of upset and you have to figure out a way to kind of compromise. Now, I also wanted to discuss the internal backlash that can come from employees and managers and whatnot, and how to address that. So one of the things I always recommend to employees is encouraging structured conversations where employees can voice their concerns while remaining productive, constructive, and legally compliant. I've found that encouraging open communication with employees in a public setting with multiple parties involved is far more effective than having one-on-one meetings where messages can get muddled and the other people involved in these issues don't have an opportunity to hear from some people with their concerns. Obviously, we know that one of the key components of DEI is emphasizing fairness and inclusion. And I think that's when dealing with these kinds of internal conflicts, that's one of the ways that you can effectively try to resolve these issues and not make it seem that any one particular group is receiving preferential treatment, as opposed to, as I mentioned earlier, making it seem that one set of employees or one demographic in your company is actually being pushed down or downgraded. It's actually an opportunity for you to explain, no, this is raising all of us to a higher level, and that's why we should be embracing such policies, depending on what those policies ultimately are. From an organizational standpoint, you can, I think, if you're willing, fold in some of the goals of DEI with the company's greater mission and its compliance obligations, and, as with most of my clients, the business success. They want to know, what does DEI do to generate revenue, and what does it do to generate profit? And if you're able to fold in what DEI does in terms of fulfilling those things, in addition to being compliant and fulfilling the company's mission statement, you're going to have a much easier time spreading it throughout the company on an internal level. Something that all of your employees, especially your managers and your executives, should be aware of is ensuring that they understand the compliance perspective and the legal perspective of DEI programs. We do have directives from the government in terms of legislation that Charlie mentioned that companies need to be cognizant, need to be aware of. And as I mentioned earlier, it shields them from potential liability. Regardless of how employees or people in the company may feel, there are legal and compliance issues that take precedent and that must be fulfilled in order to protect the company from liability, but also to continue to move the company towards revenue, profit, and not creating unnecessary issues that could be easily sidestepped with the right policy and the right. One of the things that obviously I think all of the managers are being trained on at any given company, or at least they should be, is conflict resolution. As we've seen, DEI policies and programs generate a lot of controversy. Controversy creates conflict. How do you resolve it internally? Your managers and your executives need to be equipped with the tools to address these concerns. As I mentioned, one particular method you might use is a group meeting, diffusing the tensions and preventing a poisoned work environment. And that happens, at least from what I've seen in my experience, it really happens frequently where there isn't an opportunity for the employees to express themselves in a structured and in a responsive fashion. So when they feel that because of DEI, they're being pushed down, or because of the lack of DEI, they're not being accommodated, and then they don't have an opportunity to vent those concerns, that can oftentimes lead to the feeling that they're being ignored. It's a toxic environment. And at the end of the day, it's not somewhere that they want to work any longer, which could potentially be very damaging to your company. Lastly, you obviously want to manage the internal backlash with clear policies, open communication, and legally sound decision-making, which oftentimes necessitates the assistance of a law firm in terms of drafting policies, harassment protocols. I was just assisting a business with that a couple of months ago. They were very happy with that. And so was the Ministry of Labor, who was looking into some of those issues. Soliciting outside legal advice is never a bad idea when it comes to these issues, particularly because they are changing. This is an ever-evolving area of employment law, as well as society writ large. In order to protect yourselves, it's always a good idea to reach out to Achkar Law and see if there's anything that we can assist you with in terms of both being legally sound and legislatively compliant. Charles, those are all my thoughts. Thank you.
Perfect. Well, Clifford, we're now going to put you in the hot seat for the last few minutes of this webinar. I encourage everybody who's here to submit your questions. We had some questions submitted to us ahead of them, so I'm going to start with those. But please feel free to type your questions in the chat box with the Q&A question there, because we have enough time to get through. So the first question, Clifford, how should I, or an employer, announce the rollback of a DEI program or programs? Should I use an email bulletin, or should I go and announce it, presumably in person?
I would actually use a couple of methods, because I think given the sensitive nature of rolling back these programs potentially, just by email or just by announcing it or just by going office to office, I think they're necessary, but I don't think they're sufficient. I think that if you send out an email and you talk to people one-on-one, and then presuming that your company kind of has teams, you address it on as many levels as possible. So A, there's no miscommunication or lack of clarity or confusion about what exactly is happening. B, everyone feels that they've actually been addressed in a one-on-one capacity, and it's not just an email that goes out without the opportunity for response. And then C, they see that you are actually taking the initiative to reach out to them more than just simply a firm-wide email. They see that you're actually out there in the field with them. And in my experience, having done this for a million years, employees like to know that you're in the field with them. They like to know that you're in the trenches with them, even if it's rolling back a program that might have had, some success in the past or what.
Perfect. Thank you so much. We have a live question here. How to apply this to a government organization? We've got, private companies who have these types of demands. How does this differ if it's a government funded or a government organization, like a ministry?
Yeah, I don't think it changes at all. And I actually had a very significant case. It's at the Canadian Human Rights Commission right now. We're waiting on a mediation date where these exact issues were coming up of diversity, equity, and inclusion. And what the employee in question did there was raised it to their managers on a number of occasions, ran it up the chain. Unfortunately, she didn't get the response that she was looking for. She wasn't accommodated to the effect and the extent that I think she should have been, hence the reason we're here. But the onus is no less onerous, so to speak, government organizations as opposed to private organizations. The installation, the rolling out, the implementing of these DEI policies are arguably even more necessary at the government level, considering that the legislation with respect to DEI is being passed at the government. So the last thing as a government agency, I think, you'd want is to be misaligned with the goals of the government in question.
Yeah, a lot of pressure on employers to be on the right side of this, because as I said at the beginning, they're the ones holding the bag if they don't do it correctly. And often we've seen legislation doesn't really give a clear answer, hence why you have legal assistance. And we're here to help with that. Clifford, another question came in here. This one's a tricky one of those it depends situations. But what should I do if an employee files a complaint because I removed a DEI initiative or program?
Well, I don't know the nature of the complaint, if it's an internal company complaint or potential TO complaint. And again, I hate to say it depends or it's contextual, but it ultimately will depend on what's being rolled back. Is it the entire policy? Is it elements of the policy? Is the policy being replaced with something else? Or are we scrapping the attempt to be diverse and equitable and inclusive entirely? It really will depend on the nature of the complaint. But my advice to all employers at all times is take any complaint, no matter how minor, even if it is internal, take it very, very seriously, address it immediately, and work with your employees. You'd be stunned how often simple conversations and working with your employees to fix their problems in the workplace, how far it goes, just in terms of them feeling appreciated and feeling that, yeah, hey, I am part of the team and my complaints have not fallen on deaf ears. I know that answer is somewhat cold comfort because I'm couching it in terms of contextual case-by-case analysis, but it really, really does depend. And as I mentioned, this is still an ever-evolving area, and we do not have clear and unequivocal guidance from the government or any source right now. And the courts are still ultimately going to be interpreting this as cases come down the track. I don't mean to be long-winded, Charlie, but it's a tough question to answer just outright, but I hope that was helpful.
Of course. Thank you so much. Christine, you do have one question here. We're going to wrap up with this one. It says thousands of people were hired to lead DEI initiatives, and should be the end of these projects, or should we end these projects or lay them off legal in this case? Like, this is another it depends situation, I guess, Clifford, in terms of if the project ends and there's no funding left for the project, the company and the organization, if it's a ministry, is going to have to take an evaluation of, can they afford to keep employing these people? It's going to depend on the situation. You know, if you've got people hired for a program and the program no longer exists, the company's going to have to do an evaluation there. Clifford, share your insights.
I agree. You know, it's always difficult depending on the amount of people that you've hired. If you have to get rid of a whole bunch of them, lay them off or whatnot. I oftentimes encourage employers to see if you could transition them to a different position in the company that's effectively comparable, where they can implement some of those skills, even if the DEI program is ending. It's always preferable, especially if they're a good employee, to keep them, even if you have to change their role, as opposed to having to terminate them or lay them off, especially if it's mass or there's a group of people that were hired to implement it. It is going to depend. If they're quality employees and their talent, my recommendation to any employer I work with is do everything you can to keep them in the fold, because talent is hard to find and it's extremely difficult to retain. So as Charles mentioned, you know, the onus is very onerous on the employers to be on the right side. And frankly, at this point, the right side is going to depend on a number of circumstances that really only legal professionals can assist you with in a meaningful, substantive.
That's all the time we have for questions. Thank you all for joining us today. Thank you so much, Clifford, for joining us as well. Couldn't get to all the questions that came here. And as you can imagine, every question is going to be very specific to you. If you have them, send us an email, reach out to us, give us a call. We would love to talk to you about this. As Clifford mentioned, we are in active litigation with a lot of cases that erupted based on DEI programs, the removal and the inclusion of same. So we know a lot more personally about how the landscape is shaping out, and we would love to assist you to make sure you stay on the right side of the swing of the pendulum. With that, thank you all for joining us today. Look forward to seeing you next time. Have a wonderful rest of your afternoon.
Thank you, everyone.